Okay, Katerina, we are live. So thank you to everybody for joining us today in the Art of Estate Planning. We have a special guest, Katerina Peiros from Hartwell Legal. So Katerina has very kindly agreed to speak to us about the topic of life interests. And I'm very grateful for you taking on this topic, Katerina, because I find it a very complicated one. It doesn't come up that much in practice. And I do find it to be quite a confusing little area of law. So thank you so much for agreeing to share your insights into this, Katerina, and for joining us today.
Thanks for having me.
So everybody, Katerina has prepared a comprehensive presentation for us. So I won't do too much talking. I'll hand over to Katerina. But before we do that, I just want to confirm Katerina has kindly agreed to answer questions. So feel free to throw your questions up in the comment box, and we'll either answer them as we go through if it's really relevant to what Katerina's speaking to, or else we'll bundle them all and speak to them at the end. So feel free to send them through as we go, and we'll do our best to make sure your questions are answered. So that's it from me. I'm going to go quiet and hand over to Katerina.
Cool. Thanks, Tara. Okay, so I've sort of tried to cover quite a bit in this presentation, so I feel a little bit like there's maybe 3 or 4 separate topics that have all been meshed into this one presentation. So I'll go through some things really quickly, and maybe some of them can be a topic for another day. But life interests, are they a relic from bygone era or a valuable estate planning tool? I'll give away the punchline now. I don't know. I personally have a great aversion to life interests because I've never seen one that didn't have a problem with it. So maybe I'll talk myself around. Maybe, by the end of this presentation, I'll be back in love with them. But right now, it's not looking good. So what I'd like to start with is to differentiate between 3 different types of interests, which sometimes get confused into a life interest. So in ascending order of value to the life tenant, there's the right of residence or right of occupation, which is just a mere right to occupy the property. There's a traditional life interest, or there's a portable or extended life interest. And they can be created by a will or by deed during someone's lifetime. So right of residence, really quickly, obviously only applies in respect of real estate. It's a much lesser right than a life interest. It's a personal right. You can't transfer it or assign it. And it terminates if you move out. The beneficiary only has a right to occupy the property. There's no right to mortgage the property, no right to rent it out, no right to income. So there's a very basic sample clause at the bottom of that slide. So by contrast, traditional life interest can be granted over any asset, and it's given to somebody for a period of time. So normally for a lifetime of either the life tenant, so the person who gets the interest, or for the life of another person. So, for example, the life interest is to my wife until my children are 25, or until my mother dies. We've actually got one like that. So for lifetime of the life tenant or somebody else's life, that's how it's measured. And on the death of the life tenant, or on the death of whoever it's being measured against, the capital passes to the capital beneficiaries known as remaindermen. And the remaindermen have a really tricky interest. It's an interest in possession, but it only vests once the life interest ends. Okay, so the life tenant, it's a little bit flexible for them. They have an entitlement to income from the asset. So they can either, if it's real estate, they can occupy it or they can rent it out. But it can also be a life interest over a share portfolio. So they're entitled to the income, they're entitled to use of the assets. For example, if it's a boat, and they also can create subordinate interests, which is either leasing something out or mortgaging it. so creating encumbrances. The underlying assets to a life interest can't change unless the will or deed says otherwise. The main restriction is that the life tenant has no access to capital unless the trust deed or the will permits it. The capital cannot be run down. So a life interest can be transferred or sold. So what a lot of people don't realise is that a life interest is itself an asset, and you can sell it and you can mortgage that interest. So what that meant, practical example that I had a couple of years ago, we had a spouse who was entitled to a life interest in a property in Brighton, which is a very nice Golden Mile beach suburb in Melbourne. And she brought a family provision application seeking further provision, saying life interest was not sufficient. And I think the property was worth about $2 million. And she claimed that she said, I will settle, I don't want the life interest, I will settle for, I can't remember, it was 800,000 or 900,000 lump sum. And we agreed, because what the solicitor hadn't realised and their counsel hadn't realised is that the value of that wife's life interest in a $2 million property in Brighton was about 800,000 or 900,000. So a life interest can be valued. It's an actuarial calculation, or it's done on life tables. South Australian State Revenue Office has put out life tables, and I think that they're used across the country to get a pretty good idea of what a life interest is valued at. And it's basically the value of the property, and then looking at the age of the life tenant, how long they've got left of their life interest, and applying a percentage to it. So that wife didn't really need to bring, if all she wanted was 800,000 or 900,000, she didn't need to bring a claim. She already had that. And she could have said to us, I've got this life interest, not interested in living in that huge house all by myself, I'm going to sell it. And we would have said, yep. And we did. We said, yep, fine, here's your 900, sell up. So the life interest itself is also, it's a CGT asset, and the remainderment also have a CGT asset. So that creates all sorts of tax issues if life interests are surrendered or disclaimed, or when they end, and I'll talk about that a bit later. So my greatest aversion to life interest is that essentially you've got this life tenant who has a pretty limited and inflexible interest. They can't access the capital. And then you've got the remaindermen who have this deferred interest, and they're basically waiting for the life tenant to die so they can get their inheritance. And tying people at the hip like that is never really a good idea. I just think it creates really bad karma. Sample clause at the bottom, very, very simple one. I've got a much more detailed clause, which I'll share with you at the end. Okay, and then we've got the extended portable life interest, which obviously also only relates to real estate. And what the portable life interest does is it tries to strike a balance, and this is from the Victorian case of Thompson and Thompson. It tries to strike a balance between the changing accommodation needs of the life tenant and the will maker's wish that the remaindermen benefit eventually. So in Thompson and Thompson, it was a very long marriage, I can't remember, 40 or 50 years, and the only asset of the estate was a flat in Collingwood. And on the wife was the life tenant, and on her death, the deceased's interest in the property was to pass to his children. And she brought a claim saying, well, life interest isn't enough, I can't pay for my aged care, I can't go into a retirement village, I don't have money to repair the property. And the court said, yeah, well, that's right, we'd like to give you a lot more, but we can't because the estate's very small, so we're going to upgrade your life interest to a portable life interest, which means that you'll be able to sell this property and invest the money in a RAD. And the reason that RADs are different to other accommodation is because it depletes the capital. You put in 600,000, you're not going to get 600,000 back. And the same with retirement villages, as you all well know. So essentially, the difference between a traditional life interest and a portable life interest is that you can deplete the capital for the purpose of accommodation of the life tenant or their living expenses. Okay, so in this presentation, I'm just going to focus on traditional life interests because that's commonly what's drafted and it's commonly what clients come in asking for. And also, there's so many problems with them that I think it's good to go through it in detail and leave portable life interests maybe for later. But I will talk a bit about portable life interests. So, like I said, life interests, I've never seen a life interest that didn't have a problem with it. And problems arise for all sorts of reasons. Most of the problems I've seen have been during the lifetime of the tenant. I did see one maybe 4 or 5 years ago where I thought the life tenant had died. There were no issues during her lifetime. And I thought, all right, here's finally a life interest that didn't have a problem with it. This is an amazing family. It's a first. And then what happened? So the life tenant, it was a wife, a second spouse. She outlived her husband by about 10 years. She was 93 when she died, and she maintained the property beautifully, or at least we thought so. So what happened was when she died, the executors went into the property and took some agents through. It was a beautiful house in Ashburton by the creek, for those of you who live in Melbourne. And what ended up what was discovered is that she maintained the living room and the dining room beautifully, and the rest of the house had pretty much collapsed. There was leaking roofs in the bedroom. The ceilings had leaked. There was no plumbing. Just she kept up the 2 rooms where the remaindermen and the executors would sit when they came to visit her. And they never bothered to check the rest of the house, and she just completely let it go. So what ended up happening is the estate of her husband, so her stepchildren, ended up suing her estate for the damage. So, problems can arise at any point in time with life interests. And, I don't know what we expect. We're dealing with humans, we're dealing with changing life needs, we're dealing with people who are not really bound to each other. They were her stepchildren. They were in their 40s or 50s when she married their dad. It was a warm relationship, but it wasn't one of emotional closeness. And the other thing is life interests are really difficult to draft. You've pretty much got to have a crystal ball to figure out what you need to put in. And I'll show you my clause later. Okay. So moving on, I've just put here some uses of life interests where they still probably would get used, although their life interests are not ideal. So if there's only one asset in the estate and it needs to be shared between the spouse and the children, and the spouse can't be trusted to pass it on consistently with the wishes of the owner. If it's a really small estate, if the life tenant will only outlive the will maker by a short time, or if the property must stay in the family. So they're the obvious ones. So the problems with life interest, the main source is the main source of the dispute is that there's this conflict of interest between the interests of the life tenant and the remainderment. And then you've got this poor person, the executor or trustee, who's stuck in the middle trying to balance the needs of both. So they have an overarching duty to maximise the trust for the benefit of all of the beneficiaries. But I don't know how you do that, because you've got life tenant expecting high income returns, and then you've got remaindermen who want capital growth. And so it's really difficult to balance the two. And then there's this conflict. Well, what does the executor do if, say, it's real estate that requires a lot of maintenance? Maintenance is expensive. Life tenant doesn't want to pay for the maintenance because it's not their property, and the remaindermen don't want to pay for the maintenance because it's not their property. So you've got the executor trustee being stuck in the middle. Okay. So I've got here some problems that I've come across with life interests. And these are sort of decisions that you need to make as you're drafting the life interest, although I hope you don't have to draft too many of them. So I guess first consideration is, and try talking clients out of it, do you really want to tie the life tenant and the remainder at the hip for a really long period of time? The second is, well, what's going to be the subject of the life interest? You've got to be really precise in your drafting. If you're giving, if the life interest is over the property, say the family home, is it over the family home as in the real estate or also the contents? What about if there's share scripts or, share certificates or login details to bank accounts? Does that include the bank accounts as well, or the shares, or is it just the real estate? So there's sort of the starting points, but the main issues arise around who pays for stuff. So expenses associated with use, your gas, water, electricity, who pays for that? Re Hoppy, 1967 Victorian case, says that the life tenant pays. And generally you'd expect that. Recurring outgoings like land tax, rates, who pays for that? Well, Re Hoppy thought life tenant pays, and that's been confirmed in Royal Melbourne Hospital and Equity Trustees, which is about 2007 case also here in Victoria. Insurances, probably life tenant pays, but not sure. Depends if it's contents or structural. And then maintenance and structural repairs, well, you got to make the decision when you're drafting the will. Take instructions, make the decisions. If there's no money in the estate to pay these expenses, and the roof is leaking, which is a structural repair, and the life tenant can't pay, what happens? Do you mortgage the property? Do you ask the remaindermen to contribute? Will they say yes? If it's a really long life interest, if there's 40 years to go until they get their interest, why would they put in 10, 20 grand each? Not really practical. Sometimes the problem is that we can't ask the remaindermen to chip in because we don't know who they might be. The remaindermen may not be identifiable until the life tenant has actually died. What about how long can the property be unoccupied for? When can it be rented out? I had a matter a few years ago where the life tenant moved into, I think, a retirement village or aged care, and she really wanted the family home to be rented out and for her to receive the rent. And the remaindermen didn't want to rent it out. They wanted to force her to cash out her life interest. And so they just refused to rent it out. So this property was sitting there while we went to court to force the remaindermen to, who were also the executors, to get a court order to put the property up for rent. If the life tenant can choose their substitute accommodation, so what the proceeds of sale of this property are invested in, what's the next accommodation, who chooses the accommodation? Is it the life tenant? Is it the remainderman? Is it the trustee or executor? Or is it by consent of all the parties? And how often can the life tenant substitute their home? If they're moving every 2 years, you're paying stamp duty on every purchase, so which is going to deplete the capital, obviously. And then who pays the stamp duty? Does it come out of the capital, or is it somehow attributed to the life tenant's share? So that's another drafting point. Mortgaging. When can it be mortgaged? What are the terms of the mortgage? What can the money be used for? And when does the life interest end? Does it end on the death of the life tenant, or can it end earlier, such as if the life tenant moves overseas, fails to maintain or insure the property? And the last one on that page, which is a big one, I think, is who pays the CGT when assets are sold? Is the CGT on capital account or income account? Does it come out of the capital? So is it the remaindermen who are going to pay it, the life tenant or the executor? And it's not always straightforward. Okay, next problem. Who's going to be the trustee? Who's the right person for the job? So the seminal case on portable life interest is CRISP. And sometimes when the court orders portable life interest, they're called CRISP orders. But it stands for the proposition that the life interest would not be sufficient provision for the second spouse. And in CRISP, they extended it to an accommodation fund for the future care of the spouse. I've got a New South Wales authority there that says life interest isn't sufficient provision. Interests of the spouse are always paramount, obviously, unless it's a minor child with competing need of a minor child who hasn't got parents. Thompson and Thompson said, well, ideally, you want the parties to walk away from each other. You don't want this ongoing tied at the hip kind of arrangement. But a portable life interest will be ordered if the assets are insufficient. So what I haven't talked about in my presentation is also the huge number of construction applications that arise in respect of life interests. What did the will maker mean? Okay, going to go really quickly through this. Further complexities is, what the hell do we do with the tax? Everything's a CGT event now, so how does it apply to life interests? Main residence exemption continues to apply to a family home that is occupied by somebody with a right of occupation under the will. So when that home is sold, when the life tenant dies or moves out or whatever, there's no capital gains tax to pay at that point. If the will says you can substitute the property for another home and you hold that new home on the same trust as the old home, then there'll also be no capital gains when the substitute home is sold. The issue arises if the life tenant dies and the original home is transferred to the remainderman or sold, there's no capital gains. But there may be a capital gain event if the substitute home is transferred to the remainderman. So unclear, I don't really know the answer and I haven't been able to find out. And I absolutely can't go into the CGT rules surrounding disclaimer and surrender of life interests. That's a topic on its own. There's a big ruling from the ATO on it. I think it's about 40 pages that goes through it all. So that's a topic on its own.
Katerina, I'll just mention I have a really comprehensive paper from Michael Flynn QC on the tax consequences of life estates that I can share in the group because there's only so much you can cover in half an hour or so.
Yeah, Michael Flynn's one of our he's a QC, he's one of the best people for tax and estates in Victoria. So if you shared that, I'm sure that would answer all the questions. Great. Okay, I'll just rush through this one. It's just using Victoria as an example about the duty complications of life interest. There is duty imposed on transfer of life interest, surrender of life interest, disclaimer, but there's no duty when the property is transferred to the executor, a life tenant, the remainderman, and when the titles are being sorted out. So what usually happens with life interests, at least in Victoria, is that the property will go from the name of the deceased to the name of the executor, and then the executor creates two titles. One title is for the life tenant, and the title actually says, Marion as life tenant. And the second title that gets created is for the remainderman, and the title notes the names of the remainderman and what kind of interests they hold. So each party can have their own title. Okay, I've been asked to touch on this. It's a topic of its own, and it's really not widely understood. There's not many papers on it, and it's a really horrible little piece of legislation that we've still got down in Victoria. But I think that Victorian practitioners definitely need to know about it, and so do interstate practitioners, because it applies to land in Victoria or any asset that used to be land in Victoria. So if there was a property in Victoria that was sold and a share portfolio purchased, this Act will still apply to the share portfolio. So it could be, the executors could be, or the trustees could be living in New South Wales, the shares could be all over the country, and our little Settled Land Act is going to apply. We're the only state to still have it. Everybody else has abolished it, including England. This Act came to us from England. It was introduced in 1909. It had one revision in 1928, and not since then. It's a pretty archaic sort of legislation. It's really difficult to read, and I'll tell you one clause that this will give you the flavour. So there's a clause that's called application of provisions to married women, and it says that if the woman is of full age, she can deal with her interest without the consent of her husband. So it really, it comes from a bygone era. It was all about, when it was introduced in England in the late 1800s, it was at the time of agricultural depression in England, and what they were trying to cover or improve was the life tenants were quite impoverished and they couldn't maintain the land and buildings. And so if you've read something like Pride and Prejudice or Sense and Sensibility by Jane Austen, you'll remember in Pride and Prejudice, there was Mrs. Bennet and Mr. Bennet. And Mr. Bennet had a life interest in the house that they occupied. And on his death, it was going to pass to a male heir, and he didn't have any, so it was going to go sideways. And Mrs. Bennet was quite concerned about where she was going to live once Mr. Bennet has died, and she was quite keen to marry off her 5 daughters. And the same sort of thing in Sense and Sensibility, where Mr. Collins was going to inherit the property, and everybody wanted to marry Mr. Collins. So it really sort of hails from a bygone era. It governs land in Victoria, or interests in land in Victoria, which are less than absolute. And the Act is quite often overlooked or forgotten, but it can and does lead to cases of professional negligence and breaches of trust. So one example that a barrister actually spoke to me about is there was a life tenant who inherited had a property. He got on title as executor. He then sold the property, bought another property, mortgaged that property, gambled the money away, went bankrupt. And the remaindermen, who were actually his children, sued the lawyer because, one, the lawyer had a duty to insist that the life tenant appoint a co-trustee. And the co-trustee would have said, well, no, you can't sell this property and buy another one, or you can't mortgage it. That solicitor also acted in the sale of the property, the original property, and the purchase of the next property. And so he should have known that it was contrary to the terms of the will. So the son was bankrupt, the grandchildren couldn't recover against the son, they recovered against the solicitor. Okay, super quickly. Settled Land Act, Quirks and powers. Again, separate topic, but really broadly. Essentially, the Act puts the control in the hands of the life tenant. The life tenant does need to obtain the consent of the trustee to the decisions that they want to give effect to, but the trustee can't withhold consent arbitrarily, which just means unless, if the decision is borderline reasonable, they've got to go along with it. The Act regulates how land is sold or leased, how it's mortgaged, what type of investments are allowed, what capital monies can be used for process of sale, what improvements can be made, how they're paid for. So it's quite comprehensive and really difficult to read. I had a look last night again and just doesn't even read like English anymore. Okay. So the forms of investment are very conservative under this legislation because it's intended that the capital is preserved for the remainderment, and court approval is required for a lot of actions proposed by the life tenant or the executors, and there's a presumed ongoing or regular deadlock between the parties, so it presumes that the parties will keep going back to court to resolve the disputes. Some more information. Okay, so what I thought I'd do is I would run you through, I've just got enough time to do that, I'll run you through my sample clause. So this is from my own precedent. This is a clause that I've worked on for many years, and every time I see a problem with a life interest, I tweak my clause or I put in something to have a think about when I'm drafting it. Ideally, I'd have a crystal ball every time I look at drafting one of these, and I'd know exactly what's going to happen, exactly what the progression of that life tenant's life's going to be like, what their needs would be, and I'd be able to draft a perfect clause. But you've just got to take enough instructions, give enough information, and then do the best that you can. So what I've done is the words highlighted in yellow are the ones where, particular specific instructions need to be taken. So Marion's the life tenant. If Marion, does Marion get exclusive use of the property, or can somebody live with her there? Can she invite people to live there with her? Who gets to make the call whether the property is sold? Is it Marion and the executor must do as she asks, or they may do as she asks if they think it's reasonable, or does the remainderman get to veto it? So you can include all of that in the drafting. Number 3, the subclause 3, it allows a substitute home. So this is just a residence, a land that will appreciate the same as the family home. Okay, number 4, is the executor empowered to pay for the aged care? Are they empowered to pay for just the bond, so the RAD, the capital amount that needs to be paid basically for occupation of the room, or are they also empowered to pay the daily fees? The daily fees are the ones that cover, the day-to-day care. If there's extra daily fees for, wine with their dinner or haircuts or whatever, can the executor pay that as well or not? Clause 5 deals with when can the property be rented out. You can adjust whether it's 3 months or more that the property remains vacant. Do you need Marion's consent? And how do you apply the money when the rent comes in? So here I've got, first it's applied in payment of maintenance and expenses on the property, and the rest is given to Marion. I think that because life interests are mostly used when there's only the one asset and there's no other sort of nest eggs or savings, I think, especially for the life tenant, I think if the money is there, the will-maker should set aside a fund for maintenance and structural repairs and costs of maintaining the property. And so structural repairs are obviously on the executor to do. But how does he fund that, and how far does it go? Does it go to garden maintenance? What about cutting down a tree? What about replacing the hot water unit? What if the life tenant can't afford to pay insurance? Would you want the executor to be able to buy insurance on the property? At least enough. The house burns down, at least there's enough insurance for the rubble to be removed and the block to be sold. And then if the life tenant is 90 and really can't maintain the property because they're either too frail or just don't care enough or too used to it, do you want the executor to be able to come in and pay for some extra stuff? Replace the washing machine because it's actually leaking and damaging the floor. And I've had one like that. And if you do set aside some money, you've then got to turn your mind to if all of the income, who pays tax on the income? Is it going to be the life tenant, or is it going to be the trustee, or is it just going to be so low there's no tax to pay? But how are you going to report it? And there has to be a right to accumulate the income. So if there's nothing to pay for in that year, you should be able to accumulate the income for future expenses. And I think that's somewhere in that clause. Okay, number 7. This requires Marion to maintain the house. So this clause expected to act like a good tenant. So the executor or remainderman are paying for the structure, the owner expenses, such as structural repairs. I've got here some options of what the executor can do if Marion doesn't comply. And then specific instructions need to be taken as to what happens if Marion can't or won't comply. Does the life interest terminate, or do you simply sell the property? And should you do that? Is that ethical? Is that the right thing to do? Is that what the will maker wants? If you don't have a consequence, it's a pretty toothless kind of requirement, and you'll end up in court. Sorry, that's my phone. Don't know if you can hear that. Okay, next, number 8 sort of relates to a few of the things we've discussed. Who gets to say when the property is sold? Number 9 talks about when does the life interest terminate. So does it terminate on Marion's death? What if she remarries? What if she moves overseas? Are the rights personal to Marion, or can she go live in London and let her son stay in the property? Again, that's that's instructions that need to be taken. It's not something you and I can decide. Number 11 deals with borrowing of money, so mortgaging the property, the terms of that mortgage, what that money can be used for, who you can borrow from, rate of interest, that sort of stuff. So spend a bit of time on this particular subclause. Next one, I'm sort of getting close to the end of my clause. Do you permit? So if the property is sold and any tax liability is assessed to Marion or the remainderman, who pays for that? Should it come out of the proceeds of sale, or does it come out of the remainderman's own funds? If Marion is giving up her life interest, but she's going to have a really big tax bill, is it in the best interest of the remainderman for the estate to pay it, to pay Marion's tax so that Marion is free to walk away, and she is not prevented from walking away and delaying when the remaindermen get their interest because she's got this tax liability she wants to avoid. Number 13 is really important. I think it's really important to specify, to tell the executor whose interests are paramount, because you can't really balance life tenants and remaindermen. And you don't want the family provision application because Marion, not enough income's being generated for Marion. So generally, spouse interests are paramount. So put in that Marion's interests are paramount to the remaindermen, or vice versa, whatever the instructions are, but an explanation should be provided to the will maker as to why it's important to pick who is to be looked after first. Okay. 15, I've got a couple of 15s on that page. They talk about if Marion's really on hard times, can the executor access the capital to help Marion out? Is it a broad clause like, just access to capital, or do you cap it? Do you cap it at an amount? Do you cap it at a percentage? And if you're in Victoria, you should probably make some sort of statement as to whether you are expanding Unsettled Land Act provisions, or if you're incorporating them or excluding them. That's my clause. That's it. So just briefly, and that's my sort of second last slide. What are the alternatives? So you've decided life interest really isn't going to work. People aren't getting on. It's too hard. What are the alternatives? Agreement not to vary a will is a really good option, provided that the couple trust each other. So dad can give everything to mum, mum gives everything to dad, but they put in their wills a clause that they agree not to vary the clause in their wills which on the death of the last of them divides the estates as they've agreed. So in Thompson and Thompson, that flat in Collingwood, if the deceased gave it to his wife and the wife agreed to include a clause in her will saying, on my death, the flat in Collingwood goes to my husband's children, that could have prevented the family provision application. Mutual wills is another option. It's slightly different to an agreement not to vary. Agreement not to vary is just that you just agree not to, once the first spouse has died and you've inherited, you agree that you're not going to vary the will because you can no longer get their consent. So you can change your will during the lifetime of both of you and while you both have capacity, provided you've given notice to the other party. Mutual wills are different. Mutual wills are a contract between the two parties, between the two spouses, not only that they will not vary their wills, but that a floating kind of obligation arises and floats over the assets, that the assets are going to be preserved for the next generation, for whoever the residuary beneficiaries are. Doesn't mean that the surviving spouse can't buy a new car or can't go on a holiday, but they can't act inconsistently with the flavour of the agreement. So that would mean they can't gift the money to family or charities. They can't deliberately waste it. So it requires them to act sensibly and responsibly in respect of the fund. Testamentary trusts, which are Tara's favourites, I think they are a good option because they provide a lot of flexibility both for the spouse and the children. And if you put good people in control of the trust, they can really they can improve the situation for everyone and look after everyone. Life insurance is not an option for everyone, but if you can sort of bolster your estate a little bit by taking out life insurance, that could be a good option too. So, in conclusion, what I wanted to say is that Kowalski and Kowalski Queensland decision, they said life interests remain part of the toolkit of an estate planner and are accepted as a good solution for providing for the second spouse. Yes, in limited circumstances. No, in a lot of others. But if you are going to do the life interest in a will, expert, super careful, and necessarily expensive instruction taking must take place, drafting and trying to predict the future a little bit. I think that's crucial to giving effect to it and avoiding problems for the clients in the future. I think that's it from me.
Okay, thank you so much, Katerina. That was really comprehensive and very generous of you to share your example clause as well. Thank you.
Thanks, Tara.
Now we've got a few questions come through, and I also have a few questions for you as well, if you'd like. So I'll just make us
the screen where I can see you. There you are.
Can you see us? I've just removed the slides, but if you want me to put them back up for any reason, let me know.
Good. No.
Well, thank you. I mean, look, that was really comprehensive, and it is a big topic to cover in a short time and lots of sort of threads. So I thank you for doing your best to sort of touch on everything and really dive into the heart. No, I feel like you really dived into the heart of some of the practical issues, which is really useful. Look, I think as you said, we don't have that crystal ball when it comes to drafting wills, which is always one of the challenges we face as estate planning drafters. But life interests in particular, I think, really highlight the limitations that we have when it comes to drafting them and not having that crystal ball. So thank you for your comprehensive list of issues that you and I think, I feel like everyone
there's hundreds more.
Exactly. So I wanted to ask you, when you have a client coming to you and they just ask for a life interest, what do you do? Do you just say, yep, we'll just have to really be particular about covering all the issues, or do you propose alternate approaches first?
Yeah, I try to talk them out of it. I spend a lot of time trying to talk them out of it because I think it doesn't serve the life tenant well unless there's heaps of other assets in the estate or their personal wealth. But if there is, why not just give them something outright and they can just walk away? Why are you tying these people together? So I try to talk them out of it. I give them other options. And if they absolutely insist, then I'll go through all the problems and I'll try to take as specific instructions as I possibly can.
Yeah. Now, you don't have to go into a huge amount of detail with this, but what do you think about a right to occupy versus a formal life interest or life estate?
Right to occupy, well, it's such a small right. What if you can't occupy the property anymore? You're sort of forced to stay there, or you lose your entire right. You can't sell it. You can't cash it in. You've got to stay on the 3-acre property in the middle of nowhere, even if you're 90, and you're not given substitute money for rent in a little town. So I think I would only use them where the spouse might have their own property they can move to, and they're given a couple of years, maybe, 2, 3, 4, 5 years, to grieve for losing their spouse, try and work out what they're doing, get their affairs in order, pack up and leave. I don't really use it as a long-term kind of option. Do you agree? What do you do?
I sometimes use them in conjunction with a testamentary trust where we've sort of put the right trustees in charge of the trust as well. But look, I agree. I think they're good for a sort of transition period, just to make sure that a spouse has got enough time to exit a property if they have been provided for or can go elsewhere. And then I often try to end up doing like a testamentary trust arrangement with the right to occupy or a letter of wishes sort of explaining it. But that really depends on the circumstances as to, you know, making sure the person with the right to occupy might be a trustee. And I think a testamentary trust really only works when there's enough value in the estate and passing into the trust as well. And I think that's one of the problems with life interests too. Often they're needed in that scenario where there's not necessarily a big estate, but there is a complex family situation. And it, you know, and it just makes it really, it's sort of one of those problems that doesn't have an easy solution.
No. Yeah.
Which is why I like your idea about the life insurance. You know, obviously that's a quick fix to inject some more cash into the estate. But again,
for a healthy, cashed up, I'm not too old, will make, you know, which excludes pretty much everyone who might want a life interest. Yeah.
Do you end up doing many of the mutual wills or wills with an agreement not to vary?
We've had quite a few agreements not to vary.
Yeah.
And I've actually had a test case not long ago where it came up in another lawyer's will, and I was acting for the person who was trying to knock it out, who really wanted to change the will. And we had advice, and we were told by, you know, a very, very senior barrister in Victoria that nothing can be done. She just can't change her will. She could still, you know, make some gifts and deal with the money somehow in her lifetime, but couldn't deviate too far. But agreements not to vary, they're a bit easier to draft than mutual wills. Mutual wills are horrible to draft, and I also tried talking people out of it.
I have to say, I've never done a mutual will or an agreement to vary. I would refer that on, I think.
The agreement not to vary can just be a clause. Just, you know, in consideration of receiving this from my husband, I agree not to vary clause 8 of my will. But a mutual will, it's like a contract, so it's actually a separate agreement, and you attach the two wills to it, as you would well know, but you attach the two wills to it, and then everyone can sue on the agreement. So don't do those either.
So one question, just if there's a dispute between the executors and the life tenant, which like well into the arrangement, long after the estate's been administered and any family provision rights have expired, who pays for the executor's legal fees if they have to either for baby brain, for judgment about the dispute, or if they're seeking guidance? Because I think that can be one of the issues as well, particularly where there's not a lot of wealth sitting anywhere. I mean, does it basically just force a sale of the asset?
Yeah, or reverse mortgage.
Yeah.
Which is, you know, if the beneficiary is 80 or 90, reverse mortgage is okay. But if the beneficiary is 40, you can't really reverse mortgage. So, we've got one just starting up now. It's probably going to result in the sale of the property because the life tenant and the executor just can't agree. We'll have to get judicial advice about what to do. What do you do? And the remainder men aren't putting any money in. The life tenant's in his late 50s. They're not going to put in any money. So, yeah. I
mean, as Louise, she's mentioned this in one of her comments, the pressure on the executors is enormous. So finding the right people to actually administer it, I think, is one of the challenges as well.
I agree.
Now I've hugged all the questions. We actually have.
Really, I can't see any of them. I'll just try to.
So, well, firstly, a few people have asked if you would be willing to share the slides.
Of course.
Okay.
Yep. I'll email them to you. Yeah.
Yeah, and I'll put them up and file them in the right place in the group. So Louise had another question. So in your scenario for Marion, I don't know if you remember that one. So if she renovates the house, adding considerable value, could her estate challenge the remainder men for the additional value?
On what basis? As a loan to? Well, I don't think so. Unless there's prior agreement with the remainderment. I don't think she can. She presumably the will says you've got to maintain the property. That means you can't set the kitchen on fire and you can't, scratch the bench tops deliberately. But if you've chosen to put in a brand new marble kitchen, why? No, I'd say no unless there's prior agreement. Talked myself around. Yeah.
Now, Carla, thank you for commenting, Carla. So Carla actually wants to restore our faith, and she had one that worked where her grandfather's estate made a life tenancy for her step-grandmother. And so thank you for sharing that, Carla. It is good to know that sometimes these do work.
Good. Okay. Excellent. There's one.
Now, otherwise, most of our comments are just people saying thank you for a great presentation. So
thank you.
We've gone over the hour. Thank you so much. No, I thank you for being so generous with sharing your knowledge and the information in your presentation slides. So there are some people who are watching after the fact. So if you are one of those, feel free to put your comments in and we'll keep the conversation going. But we might wrap it up now. So, Katerina, thank you so much for being so generous today. And I just want to say stay safe in Melbourne, and also to everyone else who's watching from Melbourne as well, thinking of you guys. And, yeah, I hope you all stay safe and well wherever you are. So,
thank you, Sam. Be well, everyone. Thanks for your time. Thanks
so much.
See you.
Okay.
Bye.
Bye.